draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 4 cases on for argument this morning. We'll begin with 24-2264, Davis versus Bimbo Foods Bakeries. Mr. Levine.
Good morning, Your Honors. May it please the court. I'm Randall Levine for Bimbo Food Bakeries Distribution, the appellant. The purely legal issue before the court this morning is whether a Kroger automated fulfillment center is an outlet under the contract, which is defined as a retail store that purchases products by store-door delivery. The answer to that question is no, and the judgment below should be reversed because the district court rewrote the unambiguous terms of the party's contract in a manner that is inconsistent with the agreement's text and context. First, I want to address the correct interpretations of retail store and store-door delivery.
Well, first, what's your best argument that it is unambiguous?
The parties agreed that it was unambiguous on summary judgment and agreed on the ordinary meaning of the term taken directly from Webster's dictionary. That was a place of business in which products are sold to consumers. And that, by its very terms, does not describe the center, which is a 350,000 square foot warehouse that is closed to the public, and all it does is store and sort products before shipping them to online purchasers or to other Kroger facilities across 3 different states. It is nothing like the kinds of grocery stores.
Mr. Levine, can I ask a question about that? Is there a distinction to be made between the ultimate recipients of the goods in this case? You just said that some goods are delivered to online purchasers, other to distributors. So Mr. Davis, I think, had an expectation that he would service stores that ultimately sold goods to retail consumers. So why isn't the fact that these goods are in fact being purchased, albeit online, by retail consumers dispositive, notwithstanding the fact that they are being distributed via this warehouse?
The difference is important. It's a functional difference and it's a textual difference. The functional difference is important because it goes directly to the intent of the parties and the underlying purpose of this contract. An independent distributor like Davis has a job of not merely just delivering goods to a retail store, but also interacting with the retail store and interacting with the managers of the retail store and placing items on the shelves, rotating the products on the shelves, promoting products, promoting advertising campaigns. The goal is to maximize the sales to the retail store and then to maximize the retail store's sales to the end users. None of that can be accomplished at the center. The center is just a warehouse. No one is allowed to enter the warehouse. There are no shelves to stock. There are no customers inside. The purpose of this independent distributor agreement cannot be fulfilled at this particular kind of facility.
Can that purpose be fulfilled at a restaurant, which is part of the contract?
Yes, it can.
How do you stock shelves and advertise at a restaurant?
Yeah, not every restaurant, right? But if you've ever been to a Cracker Barrel, for example, there's a retail store component where you can buy Little Debbie cakes and other kinds of baked goods there. And there's a lot of similar restaurants. And that's a part of Bimbo's business.
So does the contract only cover those restaurants?
It covers, it says restaurants, right? But there has to be a reason for the restaurant to be purchasing products by store-door delivery. It has to purchase these products from Bimbo for some reason. If the restaurant doesn't purchase these products, then obviously there's no reason to service it. The same is true for institutional accounts. Although Mr. Davis hasn't argued that the center here is either a restaurant or an institutional account. But
Mr. Levine, I'm sorry to interrupt you, but just to follow up, at what point would Mr. Davis have an argument that he is not receiving the benefit of his agreement? Say, for example, these warehouses continue to proliferate throughout his service area to the extent that the products are no longer being delivered by him, but being delivered via this distribution center to these retail consumers. Would he have an argument that he's lost the benefit of his bargain if that continues? I mean, I know that's not the case right now, but I think maybe that's what he was concerned about, is that he's being priced out or being pushed out an agreement that he signed. How long ago was this when he entered into it?
2011.
Okay. And at that point, I would imagine that these warehouses, although they existed, were not quite as ubiquitous as they appear to be now. So has he lost the benefit of his bargain?
Well, he certainly hasn't yet. Mr. Davis is still servicing exactly the same kinds of outlets that he was serving from 2011 on to this very day. As far as I know, possibly even serving Kroger outlets, because Kroger does still operate outlets, both under the Kroger name and under other names. This particular Kroger facility is not an outlet. That's the distinction. And it may be that this model grows and Bimbo is not responsible for changing market conditions or how Kroger decides to operate its business. However, the record did show, and it was undisputed, that in other markets, other independent distributors like Mr. Davis enter into separate contracts with Bimbo where there is an ability for them to serve an e-commerce fulfillment center. Everyone understands that the original distributor agreement doesn't cover those kinds of facilities, so they have to enter into a new contract. That's not possible for the Kroger facility here, and that goes to another important distinction, which is that to be an outlet, you have to not just be a retail store, you also have to purchase products by store-door delivery, and the outlet here, the center here, does not purchase any products by store-door delivery or otherwise.
What does that
Kroger
mean, Mr.
purchases-
Levine?
sorry?
Is that defined in the agreement, store-door delivery? Is that defined anywhere?
No, that is a term that has an important meaning within the context of this contract. And it's a full phrase. It's not just store-door
And
delivery.
within the
It's-
context, I'm sorry, now, I do want you to finish answering Chief Judge Diaz's question, but I'm still, at the beginning, you said this was unambiguous, and everybody agrees it's unambiguous. But didn't the district court find that there was an ambiguity in the context of this case?
The district court found an ambiguity. We think that was wrong. And the court...
Okay, go ahead and answer Chief Judge Diaz's question, and then you can come back to trying to explain why you think that was wrong.
Okay. So the full phrase is purchase by store-door delivery. And the district court erred in part by taking purchase out of the phrase. And what that refers to is the business model that Bimbo uses to service these outlets. Individual grocery stores or convenience stores or other outlets will purchase product directly from distributors like Mr. Davis. Mr. Davis purchases products from Bimbo to resell to individual outlets. That entire business model, which Bimbo refers to as store-door delivery and refers to as purchasing by store-door delivery, that simply does not apply to the center either. The fulfillment center doesn't purchase products. Kroger, at the corporate level, purchases products by submitting one purchase order directly to suppliers, many, many thousands of suppliers that will then find ways to ship the products to this 350,000 square foot warehouse. That is nothing at all like the process of purchasing by store-door delivery that Mr. Davis is so good at and has been doing since 2011 with grocery stores and convenience stores and other similar outlets that purchase directly from him. And he's responsible for ordering. And he is responsible for making sure that the grocery store or whatever outlet has sufficient product on hand for the customers that it expects. And he is responsible for making sure that the product isn't stale and that it's placed well on the shelves. Just absolutely none of that happens at the center. The center is operated by robots. And that's important because that's the intent of this agreement. And the intent of the agreement is actually very well articulated in Section 4.1, which the district court decided to ignore, but there's important context clues there. If you look at Section 4.1, it's called results, and it describes exactly what a distributor like Mr. Davis is supposed to do at an outlet. And by describing what distributors do at outlets, it also describes what an outlet is, right? An outlet is a place where a distributor can stock shelves. It is a place where a distributor can promote product. It is a place where a distributor can develop relationships and maximize sales. Those context clues are really important because not only do they modify and give content to direct store door delivery, they also modify and give content to retail store, such that even if there was another definition of retail store to choose from, and there's not, a retail store within the context of this agreement would still have to be a place where those things are possible. Otherwise, the agreement makes no sense. And there would be no reason to use a distributor like Mr. Davis for a place where none of those services can be provided. If Bimbo had wanted to enter into a contract for warehouse delivery, simply dropping product off at the back of a building, Bimbo could do that. And Bimbo does do that for certain contracts. But that's not what this contract is about. And Mr. Davis knows that and
Didn't the
understands
district
that.
court,
Yes,
didn't the district court conduct a trial and make fact findings?
yes. And
Aren't those given some measure of deference?
well, thank you for raising that because that
You're welcome.
that was really compounded error on top of error. It was error for the court to find that these terms were ambiguous and to ignore the ordinary meaning from the dictionary term of retail store, to ignore the context clues within the contract that help to define direct store delivery. And as a result, there was no need for the court to hear any evidence whatsoever to interpret what is a question of law. Right? Interpretation of a contract is a question of law for the court based upon the contract in front of it. The district court's effort to support what it ultimately did was rewrite the contract using what it called parole evidence and course of dealing. This was just further error. The material facts were always undisputed. The trial added nothing useful to the analysis. What happened was Davis called 3 witnesses. That was really the only additional evidence. And those witnesses unsurprisingly testified that they agreed with Davis. But that isn't parole evidence. Parole evidence is written or oral agreements prior to contracting that shed light on the intent of the parties. That's what parole evidence is. The opinions of 3 witnesses are not parole evidence. It wasn't course of dealing evidence either, because none of them were parties to the contract between Davis and Bimbo, and so they simply had nothing relevant to say about course of dealing. And it also wasn't evidence of trade usage, which might be admissible, because trade usage is evidence about practices within the industry that are so well established that they can be regarded as incorporated into the contract. None of Davis's witnesses testified as experts about the industry. They don't have that.
Okay, so back to the ambiguity issue. Is your argument on that you can look at the contract and everybody understands what it means and it says what it means and it means what it says and reasonable minds can't differ? Is that your argument as to why the court was wrong in finding the contract ambiguous?
Yes, that's exactly it. And that is especially so with respect to retail store. And you can see that that is true because of the way the district court needed to treat retail store and the way the district court knew the ordinary meaning definition that the parties had agreed upon from the dictionary and decided to simply reject that, not because it was unclear or not because
What deference do we owe to the district court in its finding that the contract was reasonably susceptible to multiple interpretations, and so it's ambiguous?
0 difference. That's a question of law for the court. So that's reviewed de novo. And the court below clearly got that wrong. There was no sense, and the district court did not find, that the ordinary definition of retail store couldn't be applied in this contract in a sensible way. It could be applied in a sensible way. The sensible way to apply it was to conclude that it does not apply to the fulfillment center. So what the district court did was say, I don't like that definition, and it simply invented a new one. It concluded that the definition of retail store was so elastic that it does not exclude a retailer that takes orders from customers online without the customers entering a brick and mortar location. But that definition comes from no dictionary.
It seemed to me the district court did. I mean, it used the dictionary definition and just explained what it includes and what it doesn't include. It says the definition is a place of business that sells goods directly to the consumer. And then it explained, that's the definition. That definition doesn't exclude a place that completes the transaction, right? Just the consumer giving money and placing an order doesn't sell goods. That's not complete. The district court just explained that definition that everybody agrees on doesn't exclude what happened here.
But there is a distinction, because that's not the definition that everybody agreed on. The definition that everybody agreed on from the dictionary is a place of business in which products are sold to customers.
And you got that from
Webster's dictionary.
online,
Yes.
the current version, not the
believe-
version
I
that
believe so.
existed at the time of the contract?
I believe that's right.
Did the district court have to accept the in which that everybody agreed on? If it's a question of law?
The rule under Pennsylvania law is that a court can look to a dictionary for the ordinary meaning of a common term with a common sense usage. The Pennsylvania doesn't say that the district court can edit it as the district court sees fit.
So it just seemed to me you were really emphasizing that contract interpretation is a question of law. And
Correct.
parties can't stipulate to the law, can they?
Well, I'm not sure. I mean, parties can agree not to dispute something, and the parties can agree that this was the ordinary meaning of the term.
So your point is in which does a lot of work, and that was essential, and the district court didn't include in which in its definition.
Not just in which, also products are sold to consumers, because that's an important distinction. The facility here does not sell anything. Kroger, at the corporate level, sells things on its website. It stores the products that it sells in a warehouse. That does not mean that the warehouse itself is selling products, unlike a grocery store, where products are actually sold to consumers. And that's a meaningful and functional difference. And it matters to the purpose of the agreement, and it matters to the intent of the parties. Again.
Mr. Levine,
Yes.
if at the time of the agreement, Kroger was, for the most part, selling its, or buying products from Bimbo and selling them through the traditional brick and mortar store, but then began to move away from that model to this distribution center, doesn't that, and you mentioned this at the beginning, you have no control over Kroger's business model, that's right, but you do have control over whether or not you're going to honor the terms of an agreement that at the time it was entered into didn't entirely contemplate this new business model. And so I think that's Mr. Davis's argument, and the district court's position is that your client was essentially not honoring the terms of the agreement that he entered back when he entered it.
Right, and we disagree with that, right? If what you're saying is that there should have been an amendment to the agreement negotiated to deal with this sort of new set of circumstances, or this new facility that doesn't fit the definition of a retail store and doesn't fit with the business model that had existed before, that's something that's possible. And in fact, as I mentioned earlier, the record showed that in some circumstances elsewhere in the country, Bimbo has in fact done that with distributors like Mr. Davis to address changes in the market and the increased use of these e-commerce fulfillment centers. But just because there could be another agreement that was entered into to address a new circumstance, or an amendment to an agreement that could be entered into to address the circumstance, doesn't mean that you can rewrite the existing contract to address that new circumstance. And that's what the district court did here. Right? The plain terms of this agreement do not cover a facility like the fulfillment center. That's not Mr. Davis's fault. That's not Bimbo's fault. That's just the world changing from 2011 to 2020. The fact that the contract does not cover that situation, that's how contracts work. And the district court had no authority to go back in time and to change the contract and make it into something that the parties at the time never intended for it to be. And once again, you can, yeah.
Mr. Levine, I think you're over time, but I'll ask my colleagues if they have any additional questions before you sit down.
I do not.
No.
No, thank you.
All right, you've got some time left for rebuttal. Thank you. Mr. Mictus?
Good morning, and may it please the court. My name is Daniel Mictus on behalf of the appellee, Walter Davis. First, I just wanted to say it's an honor to appear before this court. I'd like to address 5 specific points that the appellant's counsel raised, but first, I just want to remind this court that this case was not decided closely. The trial court in this case found, quote, what Bimbo has proposed as a definition frankly appears to have been contrived primarily for the purpose of ending a contract right it is not happy to be saddled with. That was one of 4 different occasions in the opinion where the trial judge found that Bimbo was simply making up definitions to suit its purposes here. The first point that I would like to address raised by appellant's counsel is that the parties agreed upon a definition and that this term was unambiguous. I'd like to point out that Bimbo's interrogatory responses, the only definition that Mr. Davis received for either term prior to trial was, quote, that the terms take on their ordinary meaning within the context of the distribution agreement and consistent with industry custom and trade usage, end quote. That's not a plain meaning, and that should dispel any current argument that these terms are unambiguous. If these terms had plain meaning, Bimbo presumably would have stated them in the interrogatory
So
responses.
appellee does not agree that the terms are unambiguous, as opposing counsel said when he was up here. He said all the parties agreed that they were unambiguous.
On summary judgment, Mr. Davis did posit that these terms were unambiguous and that they should be read in favor of Mr. Davis. The court obviously found otherwise, denied the summary judgment motions, and made a finding as a matter of law that the terms were ambiguous. And I'd also like to talk about how the trial court reached that decision. So, first of all, I think it's
And
important.
so now you are in agreement that the terms are ambiguous.
Mr. Davis does not dispute the court's finding that the terms are ambiguous. That's correct. And I think what's important is that Bimbo's primary position appears to be that because the terms are allegedly unambiguous, that the court should have just stopped at the words on the page of the dictionary definition. But the problem is Pennsylvania law, which applies here, allows and in fact requires a broader inquiry than that. Pennsylvania courts follow the restatement second of contracts. Section 212, comment B, I want to quote at length if I can, but if you want to follow along, appellee's brief at page 25, this is all quoted there. The comment B states, "It is sometimes said that extrinsic evidence cannot change the plain meaning of a writing, but meaning can almost never be plain except in a context. Accordingly, the rule stated in subsection 1 is not limited to cases where it is determined that the language used is ambiguous. Any determination of meaning or ambiguity should only be made in the light of the relevant evidence of the situation and relations of the parties, the subject matter of the transaction, preliminary negotiations and statements made therein, usages of trade, and the course of dealing between the parties." End quote. And so, Bimbo's just wrong that the court wasn't allowed to look at all this other evidence other than the words on the page prior to finding ambiguity. Here, it appears from the opinion that the trial court found ambiguity and then looked at this other evidence, but in any event, the outcome would have been exactly the same whether the judge looked at that evidence before or after finding ambiguity. And I think that's an important point.
And then opposing counsel says that the evidence that the district court considered was not appropriate course of dealing evidence or parole evidence.
Right. And with respect to course of dealing evidence, I think Bimbo's just incorrect. Bimbo's position seems to be that because the parties had never previously encountered an automated fulfillment center, that course of dealing is out the window and none can be considered. But course of dealing evidence includes the parties' course of dealing throughout their business relationship. And here, for approximately over a decade, every day the parties engaged in a course of dealing. Part of that course of dealing, the court found Mr. Davis would go to his outlets. Some of the outlets, he would take all of the actions in section 4.1. But importantly, some outlets, he wouldn't. And for over a decade, that never stopped Mr. Davis from having those outlets as one of his outlets, and it never stopped him from getting paid. It was only once this Kroger Fulfillment Center came around that Bimbo's tune changed. The next
So what services would appellee provide to this fulfillment center?
Store door delivery, Your Honor.
What would he actually do? Because opposing counsel says that his services make no sense in the context of this facility.
Right, and I think that's a good question, Your Honor, but I think appellant's counsel's position puts the cart before the horse. He's assuming that store door delivery involves all of the elements that are listed in section 4.1 and that they're expert positive. However, as the court found, and as every written definition, including their expert's written definition, provides, It's simply delivery to the store's door, and that's exactly what Mr. Davis would do here if allowed. And so when Bimbo's counsel says that he's not allowed to even deliver to the store because they make these bulk orders directly from manufacturers, well, then that's a problem for Bimbo. If the outlet doesn't want to buy directly from Mr. Davis, then Bimbo can't just go and breach the contract and say, well, I'm sorry, sir, you're out. They have to at least provide him the opportunity, and if the outlet doesn't want that, then no one services that store. That's the nature of the agreement. The next point I want to raise in response to appellant's argument is that the fulfillment center doesn't, quote, sell anything. I just want to point out that the trial court found exactly the opposite as a factual matter. At Joint Appendix page 2434, the court stated, quote, "The court specifically finds that because the Kroger Automated Fulfillment Center is a place of business that sells goods to consumers, it is a retail store," end quote. And so appellant's position that it doesn't sell anything is just appellant's counsel's opinion. It's not based in the record. And there was nothing to rebut the finding that the fulfillment center does sell goods to consumers. The third point I want to raise, and maybe I should have raised this sooner because it's potentially most important, is the purpose of the agreement and the party's intent.
So Nick, before you get to that last point that you made, what's the record evidence that the fulfillment center actually sells goods to consumers? I understood that they, collate and gather up the goods, but ultimately did they go out directly from the fulfillment center to consumers?
So to answer your first question, Your Honor, the record evidence is testimony from Mr. Davis at Joint Appendix 1497. He testified at trial question, and this is a question from the judge, Your Honor. I just want to clarify a couple things that were said. So consumers go online and make purchases from this fulfillment center? Answer, yes. Question, and the purchases arrive at their home? Answer, yes. And so the evidence is testimony that purchases were made directly from this fulfillment center. Mr. Davis himself did it. He went online, he chose that fulfillment center, he made the purchases, and the goods arrived at his home. And there's testimony to that effect as well. And your second question, Your Honor, yes, these goods come directly from the fulfillment center. The Bimbo goods and other products that are housed at the fulfillment center are delivered directly from the fulfillment center via truck to consumers' homes. And so with respect to the party's intent, Pennsylvania courts hold that the primary goal of contract interpretation is to ascertain the intent of the contracting parties. Here, Mr. Davis presented not only his testimony, but also the testimony of Bimbo's representative who brokered the sale of the distribution rights to Mr. Davis, and he was also in the room when the parties physically signed the agreement in 2011. That individual, Mr. Michael Taylor, he testified that at the time of signing that agreement, all parties' interpretation was that retail stores would have included fulfillment centers like this, and by the way, fulfillment centers like this did exist in 2011, and other Bimbo independent distributors were delivering to them under identical or substantially similar terms, such as retail store and direct store delivery. And Mr. Taylor also testified that store door delivery, the term used in Mr. Davis's agreement, certainly includes a location such as a fulfillment center because it only means delivery of the goods to the back door of the store.
Was there any evidence about how those agreements were structured, those other agreements, whether they identified fulfillment centers differently from traditional retail outlets?
Yes, Your Honor, and that goes to another point that appellant's counsel made, that other independent distributors signed these other agreements that would capture fulfillment centers. The record includes copies of the original agreement signed by those independent distributors, and the evidence shows that those agreements specifically excluded locations such as fulfillment centers. They used Bimbo's new form of distribution agreement that removed the term retail store altogether and now uses a different term called direct store delivery that specifically includes language that excludes locations such as fulfillment centers and warehouses. And so anytime that appellant's counsel points to someone signing a separate agreement or a side agreement to include fulfillment centers, it's because that independent distributor uses a different current form of agreement that specifically excludes fulfillment centers. That's the only reason.
While we're on that point, and I recall this, I think, and you can correct me if I'm wrong, one of the arguments that your colleague on the other side says is that the district court was incorrect to actually consider these subsequent agreements because as a matter of law, those weren't part of any proper parole evidence consideration or otherwise relevant.
Yes, and I think that goes to the case cited by the trial court, Pastor v. State Farm. The trial court did properly apply that. So, Pastor stands for two principles. First, a clarified contract term cannot be used to prove the meaning of the original term. However, that later clarified term can be used to identify ambiguity. And that's the only reason that the trial court here relied on the subsequent agreement. It specifically found that because Bimbo later changed those terms, it just suggested ambiguity. The court didn't rely on that later clarified term to then define the meaning in the prior agreement with Mr. Davis. And so it was a proper application of the rule in Pastor v. State Farm, and it's consistent with Rule 407 of the Federal Rules of Evidence. Rule 407 only disallows evidence of repairs or subsequent changes for 4 limited reasons that are not at issue here. However, that rule specifically says that, and I'm just trying to find the exact language, bear with me. That Rule 407 states that the court may admit this evidence for another purpose, end quote. And so that's exactly what the trial court did here, consistent with the holding in Pastor. And in the appellee's brief, we also cited numerous other cases that stood for the same proposition that later clarified terms could be used to establish ambiguity. The next point I'd like to address is that somehow Section 4.1 of the agreement, which lists actions that an independent distributor may take to increase sales, somehow has anything to do with the definitions of store door delivery or retail store for that matter. Store door delivery and retail store are defined solely by Exhibit B. Section 4.1, which is in the body of the agreement and is titled Results, has nothing to do whatsoever with the definitions of those terms. In fact, Section 4.1 uses the phrase store door delivery and outlet, so it presupposes that a location is already an outlet before Mr. Davis could take those actions to maximize sales. And I think what's important here is that you're never supposed to read terms to be superfluous or unnecessary. And if we followed Bimbo's argument here, Section 4.1 would be nothing but superfluous, because if someone using store door delivery already had to engage in all those actions listed in 4.1, 4.1 wouldn't need to say what it says. It either wouldn't exist at all, or it would just say that independent distributor agrees to perform store door delivery. And I think that's the fallacy with the argument. 4.1 exists precisely because store door delivery doesn't already require these elements. And the last point with respect to Section 4.1, both parties' undisputed testimony at trial was that providing service consistent with good industry practice as required by Section 4.1 might mean, in instances, that you wouldn't perform any of those actions. It always comes down to whatever the particular outlet wants. If they say stock the shelves, that's what Mr. Davis is going to do. If they say drop it off at the back door, like this fulfillment center apparently is, that's what Mr. Davis is going to do. That's providing service consistent with good industry practice. Your Honors, I'm happy to address other points that were raised by appellants, but I'd actually prefer to hear your questions and see if there's any concerns with the underlying opinion that we can address. And if there's no more questions, I'm happy to yield the rest of my time to the court.
I don't have any questions, but I'll defer to my colleagues if they have any additional questions.
I also don't have any further questions.
Neither do I.
Well, thank you.
Thank
Again,
you.
it was an honor.
Thank you very much, Mr. Mictus.
All right. I'll just make a few points. My colleague focused on the term store door delivery quite a bit, but like the district court, excised an important part of the full phrase, which is purchasing by store door delivery, and what that means in this context. And again, as noted, that it must refer to the business model here in which an independent distributor purchases product from Bimbo and resells to outlets. That's not just reflected in section 4.1, it's also reflected in section 3.1, where sale of products is defined to mean title to the products transfers to the independent business partner, and then is sold to the outlet, right? So that's another context clue to define what an outlet means. An outlet is a business that purchases from an independent business partner, like Mr. Davis. In the same way, section 4.1 also provides context clues to what the parties understood an outlet would mean. It is actually my colleague's interpretation that reads section 4.1 out of the agreement. How can they say that it has nothing to do with the definition of outlet when the word outlet appears in section 4.1 and it describes what's supposed to happen at outlets? That's very important evidence about what the parties understood an outlet to be, and that's what this interpretive question is that's presented to the court. An outlet is a place where an IBP like Mr. Davis can develop and maximize sales within the sales area. An outlet is a place where an IBP can ensure that there's a fresh supply of products in outlets. It's a place where an IBP like Mr. Davis can engage in marketing programs and can remove all stale or off-code products and can cooperate with the owner of the outlet to ensure that they're maximizing the sales.
Mr. Levine, you just described a number of things that your colleague on the other side would say that that Mr. Davis could do but was not required to do. And in fact, I thought the record evidence showed that in some instances, he didn't do some of those things because the store managers were inclined to do it themselves.
That's right, but that's actually not relevant to this particular question, because this question is we're trying to decide what is an outlet, right? And yeah, the question is not whether an IBP like Mr. Davis might get paid still if on a one-off occasion he doesn't stock the shelves. This is important because it means that an outlet is a place with shelves, and that's what the parties intended when they entered into this contract, shelves that can be stocked. That's how you know what the parties intended. And maybe he doesn't always stock the shelves, but that's what the parties had in mind. I see I am out of time. Unless there's another question,
Can I ask one more question? Mr.
Please.
McDis described the process by which consumers purchase goods from these fulfillment centers. Do you disagree with any aspect of that description?
I do disagree with it. The district court actually found, it's in footnote 4, and it's referred to elsewhere, that all transactions with consumers are accomplished online, on a website. And it is true that products that are stored at the warehouse, right, at the center, are picked and can be shipped to online purchasers the next day, but that's not the only thing that happens at the center. Goods are also shipped to other hubs. The evidence in the record showed that the way Kroger organizes its business is it has these big fulfillment centers, these huge warehouses in central locations that serve as like a wheel and spoke kind of a system. And so there are other outlets that can be grocery stores, it could be other warehouses sort of in the spoke outside of the center of the wheel. So sometimes the fulfillment center will ship to a consumer online, sometimes it will ship to another hub.
Thank you. Do my colleagues have any additional questions?
No.
Thank you.
Thank you. Thank you very much, Mr. Levine. I want to thank both counsel for their excellent arguments. My two colleagues will come down and greet you, maybe shake your hand twice since I can't do it, and then we'll move on to our second case. right, our second case,
Yep. So Chief Judge Diaz, I don't know if you can see the courtroom. We still have to switch counsel.
okay.
And everybody's still standing.
Oh, please be seated, sorry.
Please, go
Yeah,
ahead.
so please be seated and we can switch.
Okay, our second case is 24-7118, Langford versus Stonebreaker. Mr. Evans?
Yes, sir. Good morning, may it please the court.
Morning.
My name is Tommy Evans. I am a Assistant Attorney General at the South Carolina Attorney General's office. I am representing Warden Donnie Stonebreaker for this proceeding. The district court ruled that the South Carolina Supreme Court was not privy to the information regarding the petitioner causing the delay of his trial. We will argue that the district court's interpretation of the record was incorrect. I think that the district court made a mistake and overlooked some findings in the record that will reveal that the Supreme Court did have information from testimony during the trial that it's a possibility that the petitioner or the appellant respondent in this case did actually cause a delay in the trial. Therefore, they were not entitled to a speedy trial motion. There was testimony in the trial revealing that the petitioner caused this trial time to be lengthened because of his harassing his co-defendant, Mr. Alvin Phillips, who was essential in the state's being able to prosecute his case since there were no identification from the victims or any forensic evidence linking the actual petition to the scene. Alvin Phillips' testimony was essential in this case. It was necessary in order for the state to go forward and to be able to get a conviction on this case. In the appendix on page 758, lines 15 to 21, and page 759, lines 13 to 15, the record revealed that Alvin Phillips did testify that the petitioner forced him to sign his statements refuting the earlier statements he made to law enforcement. Also, Investigator Young, who was the chief investigator in this case, also testified, and you can find an appendix on page 865, lines 6 through 9, and 16 through 24, that Mr. Phillips had to be moved to a different facility from concerns of him being influenced.
Mr. Evans, can I ask about that? So what
Yes,
is
sir.
the sequence of that testimony? Did that occur before the South Carolina Supreme Court ruled on the motion, or was that evidence that came in after the fact?
No, that was before the South Carolina Supreme Court got the case. That was actually trial testimony, was part of the record that was provided to the Supreme Court during the appeal, Your Honor. There is also no dispute this case was essentially called for trial. Now, this case was called for trial 2 years after his arrest, and that's his indictment, which the court stated was troubling for it to last that long. But the reason was...
Does the state not also think it's troubling that it took 2 years to bring this case to trial?
No, because it wasn't intentional, Your Honor. They was trying to get... The victim was Chinese. They couldn't speak English. So the state had to find a certified interpreter that
I
speaks
know
Mandarin.
that the court said that, but the state never really, I didn't see where the state gave that as a reason for the delay. The state did give as a reason appellee's interference in trying to change the witness testimony as multiple reasons.
Yeah, yes, sir. Yes, ma'am. I think that the original, during the original speedy trial motion that was made before the circuit court judge prior to trial, where the judge ordered that the case would be tried within 9 months, that was the reason for the delay that the state gave. That's one of the reasons for the delay, getting the interpreter, which took time.
Way back at the beginning.
Yes, ma'am, way back in the beginning.
So you're saying it took 2 years to find the interpreter?
That's what they're saying. It took 2 years.
Where in the record did the state say that? I mean, I read all about I know that the state argued multiple times in multiple ways that the interference with, the attempted interference with the witness was the reason for the delay. And I did see that they had some trouble finding an interpreter, but I didn't see them giving that as a reason for the delay.
Well,
But you're saying it was somewhere way back in the beginning?
in the beginning, and beginning prior to trial, prior to anything happening, that's one of the reasons that the delay was caused by getting an interpreter, which the court found troubling, but the court also found it wasn't done intentionally. They didn't do this in order to delay. They just had trouble because there were no Chinese interpreters in South Carolina.
And is that factual finding is entitled to a presumption of correctness, right, under AEDPA?
Yes.
And so the burden's on the petitioner to show by clear and convincing evidence that that factual finding is wrong.
Yes, and that was never done. There was never any accusation raised by the petitioner that the delay was intentional, that the finding of the Chinese interpreter, that the state did that intentionally in order to delay this case.
And I didn't see any finding by the district court, although I guess finding is the wrong word, any ruling by the district court about any prejudice from that first 20 months. It looked like the magistrate judge and the district judge only talked about the last 4 months when they talked about prejudice. Is that right?
Yes, ma'am. And we found there was no prejudice because the case was actually going to be called for trial. But since Mr. Phillips decided the day of trial not to testify, and he was only appointed a lawyer 8 days earlier, so his case could not be called for trial because his lawyer would not prepare it. They couldn't go forward at that time. So the prejudice did not occur because the case could have been called for trial if no interference was done by Mr. Phillips, causing him not to want to testify at that time. That delay was not caused by the state. The state
Right, the state's argument is the delay was caused by, that it's Appellee's own fault that there was delay because Appellee allegedly was interfering with the witness, correct?
Yes, ma'am. Yes, ma'am.
Could you address the ineffective assistance and hearsay issue?
Well, my co-counsel will be
okay.
rebuttal, and he will be more going into the actual interpretation.
In rebuttal?
Yes, ma'am, going to confrontation laws and also
And how is?
and also the and also the hearsay argument.
And Mr. Evans, sorry to interrupt you, but I want to go back to this issue of the interference because that's sort of what both the magistrate judge and the district court hung their hats on, that there was no record evidence of interference presented to both courts, as I understand it. So did the state point the courts to where that record evidence was? Because I find it hard to believe that if you had pointed the court to that evidence, that the court would not have focused on it.
I'm going to fall on the sword. We did not do that, and it's my mistake that didn't happen.
Well, then that sounds like you forfeited that argument.
Well, I wouldn't say I forfeited that.
Did you tell the court that this evidence existed and just not cite it?
No, we did not. But my opinion was not forfeited because that was always our argument that they interfered with this evidence.
Then how could we fault the court below for not addressing something it was not aware of?
Well, according to 2254, the determination of facts in light of the evidence presented in the state court proceeding. So our position is under 2254, that is evidence in the state court proceeding. So that is evidence that the trial court must consider.
And the standard under 2254, right, is has to be unreasonable beyond what any fair-minded jurist could conclude, but it looked like the district court instead was assessing the sufficiency of the evidence before the South Carolina Supreme Court.
Yes.
Now, maybe it assessed that incorrectly because you didn't point out that the trial had a plethora of evidence. But it seemed to be asking the wrong question and kind of de novo reviewing what the South Carolina Supreme Court had done to see whether the South Carolina Supreme Court had sufficient evidence to make its conclusions, rather than asking the appropriate AEDPA question of whether this is beyond what any fair-minded jurist could conclude.
I would agree, Your Honor. That's our position. Also, our position is that the evidence was there. And 2254 states that in order to grant a habeas petition, it has to be an unreasonable determination by the courts with under the records that exist. And under these records, there exists some evidence that state Supreme Court was informed of this delay being caused by the petitioner himself.
And what's the standard for our review of the district court's work?
I think the standard is that you will make a determination whether or not the district court was correct in the assessment.
It's de novo, right? We de
Yes.
novo review whether this was an unreasonable determination by the South Carolina Supreme Court, right?
Yes, ma'am. Yes, ma'am.
So we can look at all the evidence because
I
we
think-
know it exists.
I think that that's the authority of this court. If the district
And
court made
what's-
a mistake, the authority of this court is to correct those
And
mistakes.
what's the record, the best record evidence in your view that the state Supreme Court had about the delay being appellee's own doing?
The trial testimony itself, Your Honor, from Mr. Alvin Phillips and also Investigator Young. That was evidence that was provided to the South Carolina State Supreme Court. I mean, in his own order, the district court referred to the Langford decision. And in that order, in Langford, which can be found at appendix page 2118, Supreme Court specifically said, and this is from the order of the district court, from our review of the record, there was evidence that Langford and his co-defendant persuaded Phillips to remain silent. That's from the Langford decision that's in the order.
Was Investigator Young called by the state or only by the co-defendant?
I think Investigator Young was called by the co-defendant. You know.
The state didn't call Investigator Young,
The state didn't call Investigator Young in the case.
just benefited from that.
And also in the appendix in 2118, Supreme Court stated that the loss of this crucial piece of evidence therefore effectively gutted the state's case and caused the delay of trial. And as I said before, once Mr. Phillips decided not to testify, that pretty much put the state in a conundrum because he made the statement on the day of the case was going to be called for trial. So the state had no other alternative but to ask the court for a continuance in order to possibly bring Mr. Phillips to trial or persuade him to change his mind and testify during the petitioner's trial, which he decided to do without any assurances of a sentence, Your Honor. And so our position is that the district court just made a mistake in this case, made a ruling where there was evidence before the Supreme Court that this occurred, and we will ask this court to reverse the decision of the district court and remand it back to the district court. I'm almost out of time. Are there any further questions from this court?
I don't have any.
Thank you.
Thank you. Thank you very much, Mr. Evans. Mr. Gross, I'm sorry if I'm mispronouncing your name.
Excuse me, Your Honor, it's Gross. You had it correct. Good morning. May it please the court. I'm very honored to be here. I'm also honored to be here with Casey Langford, who is my client in this matter, who has been released pending the appeal in this case by the district court. Mr. Chief Judge, I want to go back to a point that you raised and the panel in the courtroom picked up on with regard to the forfeiture, particularly with the allegations that Mr. Langford was responsible for causing the delay. First of all, we disagree with his being the cause of it, but if you look at both the report from the magistrate, the United States magistrate, as well as the report from the district judge, they both commented on the fact that the state failed to point to any particular part of the record where it was alleged that there was support for the fact that Mr. Langford was responsible for the delay. The state had an opportunity to object to what the magistrate said in her report and recommendation. They did not include that in the objections. And the case law, I think, is clear from the United States Supreme Court that if a party fails to object to the report and recommendation, then they forfeited or they waived that
And then
argument.
I thought opposing counsel argued that the support for that is in the transcript of the trial itself, in the testimony of the co-defendant and I guess of Mr. Young, or Investigator Young as well. What's your response to that?
Well, I disagree with their characterization of it. For example, you know, they're arguing that that Mr. Langford put pressure on Alvin Phillips. If you look at Joint Appendix page 760, let's see, actually it may be, yes, the solicitor asked, did you sign them to please them? Were they pressuring you to sign those? And the response was no. That was the testimony.
You're re-arguing the case, though. I mean,
I'm not
at 7:58, right, Alvin testifies, that's not my handwriting. They gave me this note to sign so that nobody would get in trouble to asking me to change my testimony. That's cited to the state Supreme Court. The state Supreme Court was informed about all of this by the state. Now, you're pointing out they didn't cite it to the magistrate and to the district court, right? And you're asking us to find it waived because it wasn't cited there. But it was cited, it was at trial and it was cited to the state Supreme Court, and we're reviewing that for whether it was unreasonable.
The first thing, Judge Rushing, is I think that what was cited to the state Supreme Court, what they argue here today, is different than what's in the record. The record is not that there was any pressure. Mr. Phillips expressly denied being pressured. The only evidence is that he was asked to sign a statement, 2 statements. He signed those statements.
So are you saying that, is that your clear and convincing evidence? Is that your evidence that that we can find by clear and convincing evidence that the state Supreme Court made an incorrect finding of fact that petitioner was involved in any way in the final 4 months of delay?
I don't think that you can look at this record and say that Casey Langford was responsible for the final 4 months of the delay. I don't think you can do that. I think that the evidence that was before the state Supreme Court was that one person asked somebody else to do something and they did it. There was no pressure involved.
Who did Mr. Phillips testify gave him the statements that he was asked to sign?
He did testify that Mr. Langford did that.
And they were exculpatory statements?
They were exculpatory statements.
Mhm.
Yes. And though, while, I mean, I want to go back to this issue of the forfeiture because the magistrate specifically stated that
Doesn't the forfeiture rule mean if a party fails to object to the magistrate's ruling at all, then it's considered forfeited for appeal?
No, I don't think it's
But
that.
if they object to the magistrate's opinion, it goes to the district court, and the district court reviews either for clear error on findings that aren't specifically objected to, or it reviews de novo, right? And then all of that comes to us.
Well, I think that the law is that if they don't object to that particular finding, then they forfeited that for the appeal.
But that's not how the district court treated it. Respectfully, I disagree with your perspective on appeal, but the district court reviewed all of that for clear error, right?
And the district court reviewed what they asked them to review. They asked them to review the motions hearing, and they found that the statements by the solicitor were not substantiated. They didn't ask, there was a number of places.
And when you say the statements by the solicitor, you mean that the statements that appellee, or, that appellee caused the delay?
Correct.
They certainly objected to that part, right? The part about the delay.
Well, they asked the district judge to look at what was at the motion hearing, the May motion hearing before I believe it was a September trial, and the district judge and the magistrate judge both looked at that and reached the same conclusion that Mr.
So they
Langford.
objected to that issue.
Well, they reiterated, they argued that Mr. Langford was part of the delay, but they did not point to what they're pointing to in their brief and what they're pointing to here today. They didn't point to it in the, the objections to the magistrate, and so I think that is where the forfeiture comes into play on that issue. I mean, they candidly
Because
admit.
some of the things they point to are after the state Supreme Court decision.
In fact,
Correct.
their argument below was almost exclusively about the testimony of the assistant solicitor during the PCR hearing, which was months, if not years, after the state Supreme Court decision.
Can I ask you about the 20-month delay?
Yes.
What's your clear and convincing evidence rebutting the presumption that the state was at most negligent in that 20-month delay?
Well, I know that Justice Hearn at the oral argument pointed out that there was a Chinese immersion school in Columbia, South Carolina. I think the questions earlier was that, the state really wasn't saying that they had a hard time finding a Chinese.
Sorry, the standard is clear. What's your clear and convincing evidence to dispute? The state court made a finding, right, that the state was at most negligent in that 20 months. So you have to give clear and convincing evidence to disprove that.
Okay. Well, the clear and convincing evidence is what the magistrate judge found and what the district judge found and what the South Carolina Supreme Court found in the portion of this opinion, which is that the reason for that 20-month delay was because the solicitors controlled the docket, and that violated the state constitution.
Right, so the state Supreme Court thought about that, the solicitor control and the interpreter, and concluded the state was at most negligent, and that's what you have to overcome.
Well, but they did not analyze, as the magistrate judge pointed out and the district judge agreed, they did not analyze the role that solicitor docket control played in that first 20-month delay.
Did they not? Because it looked to me like the whole point of considering, the speedy trial argument at the state Supreme Court, it was a little odd. That was just a prejudice inquiry, right? The whole argument was about solicitor docket control, at least according to their opinion, right? I know it was sua sponte, but they were focused on solicitor docket control and then asked, did this prejudice him by causing a speedy trial violation? And then they looked at speedy trial. So it was surprising to me that the magistrate would say the court was not thinking about solicitor docket control when it made that ruling.
Well, you look at the four corners of their opinion, and they did not address the role that solicitor docket control played in that.
But you agreed that was the bulk of the opinion was about solicitor docket control.
I agree.
And they found it unconstitutional.
I agree that was a significant part of the opinion, but the issue that was presented to the South Carolina Supreme Court was whether or not Mr. Langford's right to a speedy trial was violated. The Supreme Court, between this case and Brian Phillips' case, had almost 100 minutes of oral argument that morning where solicitor docket control was part of it. But that was brought in through the amicus brief, but the main issue, Langford's main issue in the South Carolina Supreme Court was the violation of the speedy trial. In fact, that was the only issue that he appealed to the South Carolina Supreme Court. And while solicitor docket control became a monumental part of that case, it was not addressed in the part of the opinion that talked about that 20-month delay. And so that would be our position there.
Can you address the hearsay and ineffective assistance part of the case?
I can. And I think that you asked Mr. Evans, Judge Thacker, about who called Investigator Young. Brian Phillips' lawyer called Investigator Young. And I think that you have to look at all of Investigator Young's testimony, both the direct.
But this is just a challenge to, just a confrontation / hearsay challenge, right? Not to all of his testimony, just a failure to make an objection on hearsay grounds?
It's failure to make objection on
confrontation
hearsay
clause.
and confrontation clause,
Yeah.
both of those grounds. That is the challenge. So when Brian Phillips called Investigator Young, they asked about talking to this informant, Stevens, and receiving information, which included the 3 names. And then when
Do you think, did Phillips offer that testimony implicating himself for the truth of the matter, for the truth that he did commit the crime?
I think that was the effect of the testimony, but if you look at the cross-examination that Mr. May made, he asked about, did Mr. Phillips did Mr. Stevens give you these 3 names, Alvin Phillips, Brian Phillips, Casey Langford? Did he tell you that they committed these crimes?
So sorry, is this the cross or the direct?
It's the cross-examination.
So this is not the part that you say he should have objected to?
He should have objected to he should have objected to all of it. Should have objected to it when it was first asked.
Okay.
What information did this Mr. Stevens, who didn't testify?
Did somebody else that's not in the courtroom tell you, let's hear what somebody who's not here to testify today has to say? That's when he should have objected.
And that would have shut down everything. That would have shut
Maybe.
down naming those names. It would have shut down the solicitor's cross-examination. It would have shut down the solicitor using that evidence and emphasizing that evidence in his argument to the jury. Basically saying, the solicitor was arguing it was true. He said that Mr. Stevens gave the exact same information that Alan Phillips gave
But
on the stand.
you didn't raise that he didn't object in the closing, right? I just want to keep us focused on.
Well, that goes
This
to
is
the
a question
prejudice.
about whether he objected to his co-defendant presenting this evidence about the investigation, right? How they got the names.
And he should have objected. That would have shut down that question, the cross-examination, and the closing.
And then he should have objected when he was first called. It's your argument, he should have objected when the cross-examination occurred to establish the truth of the matter asserted, and then he should have objected during closing.
Correct. And that initial objection, though, would have shut down everything.
Well, could have,
Yeah.
we don't know.
What's the double layer of hearsay here? The magistrate and the district court called this double hearsay?
I think that they're referring to the fact that it was a statement that Alvin Phillips supposedly made to Mr. Stevens, who then was repeated to.
I didn't see that I just saw that Mr. Stevens told the officer.
Well, where Mr. Stevens supposedly got the information from was, I believe it was from Alvin, but it was from one of the.
I didn't see that in the testimony. It looked like maybe just one layer of hearsay, but if that's what it is, I guess the question, though, is why do we believe this was offered for the truth when a co-defendant introduced it to explain the investigation?
Well, it was not a valid trial strategy. That lawyer has been.
Yeah, that lawyer,
Yeah.
Another court's already found that he was ineffective for, not for failing to object on hearsay grounds, interestingly, but for introducing this testimony and other various problems.
If it wasn't a valid strategy for him to introduce that testimony, why was it a valid strategy for Mr. Langford's lawyer not to object to that testimony?
Well, then we also have to go through, I didn't see the district court do this, but, there's a prejudice inquiry to Strickland.
Yeah.
So not only could he have objected, but would the objection have been sustained? And if the evidence was kept out, would the outcome, do we have is there a reasonable probability that the outcome of the trial would have been different? Don't we have to go through all those steps? What's your argument for those steps?
And you shut me down a minute ago, but part of the argument for the prejudice was how it was used in the closing argument. Judge Keesley's a very good judge. I think that Judge Keesley would have got it. He would have sustained that objection. And then you would have had, just the testimony of Mr. Phillips, who was impeached by the prior inconsistent statements that he gave. You wouldn't have had the ability, this was not a case of overwhelming evidence. They didn't have anything other than the co-defendant's testimony for which he was going to be rewarded through. They had nothing else. There was no eyewitness identification. There was no DNA. There was no other corroborating evidence except for this evidence from Mr. Stevens. So I think the outcome of the trial would be different. So I believe.
And then I guess the final layer is it would have been unreasonable for any jurist to conclude otherwise. Is the final step.
I think so. Yes, yes, and certainly, the district court didn't rely on Judge Maddox's opinion or order in the co-defendant's case. The magistrate did. Judge Coggins didn't discuss that, but you also have, that's some evidence that, in addition to our argument that it was prejudicial and warranted a new trial.
You have anything else, Mr. Gross?
I would just add, again, this is a situation where, the big part of the decision was based on the confrontation clause, and the state never really argued the confrontation clause in its objections or to Judge Coggins below. Unless there's any other questions, I'll yield the balance of my time. Thank you.
Thank you very much. Mr. Larrabee?
Good morning, Your Honor, and may it please the court. My name is Brandon Larrabee. I'm an Assistant Attorney General, also representing the warden in this case. The Confrontation Clause is intended to keep may it please the court. The Confrontation Clause is intended to keep testimonial hearsay out of the courtroom. If a statement outside of court is not offered for the truth of the matter asserted, it is not barred by the Confrontation Clause. And we know this because the Supreme Court has said that repeatedly, most recently in Smith versus Arizona, and that's 602 U.S. 779. The court in that opinion said, when a statement is admitted for a reason unrelated to its truth, we have held the clause's role in protecting the right of cross-examination is not implicated. That's at 785. At 793, it quotes Crawford. It says, and that means the clause, quote, does not bar the use of testimonial statements for purposes other than establishing the truth of the matter asserted. So one thing I think it's important to realize is that when the respondent argued below that the statement in this case was not hearsay, that was an argument on the Confrontation Clause. To find otherwise would be akin to saying, for example, that the state did not argue negligence below because it didn't argue causation in a civil case, for example. The issues are one and the same. And Investigator Young's testimony was not hearsay for some of the reasons we've already heard this morning. It was not offered to prove the truth of the matter asserted. In this case, the co-defendant was trying to offer that testimony in order to cast doubt on the origins of the investigation into the three defendants here.
But the cross-examination was for the truth of the matter asserted, I assume, or you wouldn't have also argued it in closing argument. So does it not matter because it was cross-examination and not a question elicited on direct?
Well, I think by that point the evidence had already come in. If you look at Joint Appendix 853, lines 13 through 20, that is an example where in the defense's initial examination, he talked about the three names, Investigator Young talked about the three names that were submitted to the court. So I think if anything, you could say that there's no prejudice there because it would have already been in evidence.
Well,
Or you
that
could say-
objection would have been overruled, right? Because the evidence was already in.
Exactly. It's essentially sort of a door opening.
Or you could say, I mean, you just said the harm had already been done, so, or you could say, or now the prejudice had already been committed, now it's doubly prejudicial when it's asked on cross-examination, and then triply so when it's brought up in closing argument. And that's another way you could argue it.
Well,
Not you, of course, but somebody.
Except that that doesn't really get to the hearsay, because the hearsay is what it was offered for. And the purpose it was offered for initially was to cast doubt on the origins of the investigation. That would have happened
Mr.
regardless
Larrabee,
of
can
whether
I,
the state
sorry to
brought it
interrupt
up on
you, but
cross.
Was the jury told what the purpose of that evidence was being introduced for?
I don't know if I can cite you a record reference on that, Your Honor, so I'd have to look back at it. I think that
Well, I mean,
that
if
the
that's not,
question.
well, if it wasn't, and in fact, the evidence was then used on cross-examination in the way that Judge Thacker described it, why isn't that ineffective assistance of counsel at a minimum? If in fact, your point is that this wasn't hearsay, it would seem incumbent upon a competent defense lawyer to emphasize that point in an instruction.
I understand what Your Honor is saying. I guess, again, the issue would be here that there was, the initial reason for the testimony had already established that the three names were given in that case. And so if anything else, it didn't add to the record. It didn't add anything to the record that wasn't already there. I don't know that the court has a history in South Carolina, or a habit in South Carolina, of instructing the jury on rules of evidence and what things are or aren't offered for, except in certain cases. Obviously, there are instances like the the petitioner's record, if that's all argued on his examination, things like that. But I don't know that they make a habit of spelling out, explaining hearsay to the jury.
Okay, well, let me ask this. So you mentioned that by the time cross-examination began, the evidence had been entered and offered, as you say, not for the truth of the matter asserted, but didn't the state court already determine that that lawyer was ineffective in part for doing that?
If you're referring to Judge Maddox's opinion, Judge Maddox is not actually looking at this as a confrontation clause issue. And the issue he's looking at isn't even whether or not that testimony was objected to. His issue, and you can see this in the heading on Joint Appendix 102, is calling Young as a witness. And his argument is that the state might not have been able to get this in because it would have been hearsay if it had been offered by the state for the truth of the matter asserted. The fact that the co-defendant's lawyer, Brian Phillips's lawyer, called the witness and allowed him to testify, brought his testimony forward, was what Judge Maddox found was ineffective assistance on that ground. I think that the hearsay issue, I don't think it's essential to Judge Maddox's ruling, because I think his argument is it wouldn't have come in if the state had offered it. But it was able to come in because it was being offered for something other than the truth of the matter asserted. That's how I would read Judge Maddox's order in that case. And even so, as far as the difference between Judge Maddox and the judge in this case, we point out that habeas is aimed at making sure the decisions are within a range of reasonableness. Just because two judges come to different conclusions, that does not mean that either of them is necessarily unreasonable, as that's meant under the federal habeas laws. I see that I'm running out of time, so if I have no other questions, then we would ask the court to reverse the order of the district court.
All right, thank you very much, Mr. Larrabee. Appreciate your argument. Thank counsel for their fine arguments this morning. Mr. Gross, I can't see you, but I want to thank you for taking on the representation of your client in this case, which you've done pro bono And we're grateful to you for doing that. We could not do our work without lawyers who were committed to doing work. And some were not getting paid for doing court-appointed work and pro bono work. So thank you on behalf of the court. We'll take we'll say a 5-minute recess, and if my colleagues, if you need more time than that, just have the clerk alert me and we'll take more time, but we'll take a 5-minute recess before moving on to our last 2 cases.
But we'll come down and greet counsel before.
Yes, thank you.
You can be seated while we await Chief Judge Diaz.
Thank you, Your Honor.
Maybe it wasn't 5 minutes. Maybe I should take. No.
My apologies. I'm ready to go if the court is, if the floors are. Our third case is 24-1401, Coffeeair versus Tams Management, Inc. Mr. Ruby?
Thank you, Your Honor.
May it please the court, Steve Ruby for the appellants. The crux of this appeal, Your Honors, is that the plaintiff neglected to prove an essential element of his case at trial, that he was employed by a qualifying employer under the WARN Act. Now he asks this court to extend WARN Act liability in an unprecedented fashion and impose liability on a separate company, Tams Management, that was not a parent or a subsidiary of any of the other defendants. The court declined to do that in the Pennington case in 2019, and it should decline the invitation to upend the precedent from Pennington today. The WARN Act, Your Honors, requires a plaintiff to prove 6 elements. The second of those is that the plaintiff works for a qualifying employer. A qualifying employer, as pertinent to this case, is one that has at least 100 employees. It's undisputed in this case that Tams Management, which was the plaintiff's employer, Mr. Gautier's employer, did not have 100 employees, and so the plaintiff has relied upon a single employer theory under which, in certain circumstances, multiple business entities can be aggregated together to meet the 100 employee threshold required to trigger the WARN Act. There's a DOL regulation, 20 CFR 639.3A2, that governs whether multiple employers can be aggregated into a single employer for purposes of the WARN Act analysis. And the problem with the plaintiff's case is that he neglected at trial to present evidence to the jury that could sustain a finding that Tams Management was part of a single employer for WARN Act purposes.
What about all the testimony at trial? Do you not think that the testimony is evidence?
Your Honor, we don't believe that the testimony that was presented was sufficient to, and I'm happy to go through that piece by piece, Your Honor, or factor by factor. We don't believe that the testimony was sufficient to establish any of the 5 factors that control the single employer inquiry under the DOL regulation.
Well, and you mentioned Pennington, and Pennington's a big part of your case, but Pennington is distinguishable from this case, isn't it? Because there were no common directors or owners, and they were operated as separate entities in Pennington. And here, I mean, the entire Justice family, it appears that they were running the show at this company, at all the companies, at all 5 entities.
So, Your Honor, and I'll take that piece by piece. Your Honor's comment mentioned ownership, directorship, as well as oversight of operations, and those go to multiple factors in the DOL regulation. The first factor, and this goes to Your Honor's question, is common ownership. That's certainly one of the factors under the DOL regulation, and part of the problem with the evidence the plaintiff presented at trial is that there was no evidence presented to the jury that Tams had any common ownership with the other defendants. There was, and I believe that's
Why were they having weekly conference calls with Jim and Jay Justice about the operation of the business?
I think that factor, and again, there was no evidence presented to the jury on the ownership of Tams. There was evidence presented that there were conference calls with Jim Justice, that there were conference calls with Jay Justice. I think the plaintiffs have discussed that under the factor of de facto exercise of control, which is the third factor in the DOL analysis. There's no evidence that, first of all, the TAMS, which is Mr. Gautier's employer, exercised any control over any of the other defendants. There's also no evidence of which of the defendants, if any of the defendants, the justices were acting on behalf of when they had these weekly conference calls. In other words, were they acting on behalf of TAMS?
What about when they showed up there? Didn't they show up at the job site on occasion, Jim and Jay Justice, to oversee I assume to oversee operations?
That was the testimony, Your Honor, but I'll analogize that to the situation in Pennington.
Did Jim or Jay Justice testify and say, no, that we didn't do that?
They did not, Your Honor, but it's the burden, of course, of the plaintiff to establish that there's a single employer under the DOL regulation analysis. In Pennington, the situation, as I know the court's aware, is that there were 3 levels of supervision. There was a utility company that was the principal in constructing a nuclear power plant. Westinghouse was the general contractor or a contractor in constructing the nuclear power plant. Fluor was a subcontractor for Westinghouse. And the facts there, I think, are analogous to the facts here, Your Honor, in that there were personnel that were on site from the utility. There were personnel that were on site from Westinghouse, which was the contractor, which had the authority to give direction and to coordinate the work that was being done at the site, even if that work was being done by Fluor. But the touchstone, the central principle from the Pennington case, when it considered those facts, is that a degree of coordination, that's the critical phrase from Pennington, a degree of coordination is not sufficient to establish single employer status. I don't think there's any doubt that the testimony
A degree, what did you say? A degree of what?
A degree of coordination, Your Honor.
All right, a degree, but here, at least from the testimony, the jury could conclude that this was total coordination.
Your Honor, we don't agree with that.
And perhaps they did conclude that.
We don't agree that the testimony would establish that, but we also don't believe that with regard to if you look at the totality of the DOL regulation and the 5 factors that have to be established, first of all, there was no evidence of common ownership between TAM's management and the other defendants. There was no evidence presented at trial.
Why do you say that? I know there weren't formal documents, but employees and other people testified that, oh, the justices own this one, they own that one. That's testimony, that's evidence. You might think it's incorrect. People called TAMS a subsidiary of other companies. That might be wrong, but it's evidence, isn't it? And you're supposed to present evidence to oppose that.
Judge, I don't believe there was any evidence in the record specifically of the ownership of TAM's management. There were statements about that the justices, there was an affidavit, and it's important, I think, not to conflate the affidavit that was presented at an earlier stage of the proceedings, which reflected
Right,
the
but
owners were of
people,
TAM's.
the affidavit wasn't in front of the
Correct, Your Honor.
jury, but people testified, calling them all the justice companies, TAMS, Bluestone, all of them. Now, this factor's not make or break. There are other factors in the analysis, but I hesitate when you say there was 0 evidence on this. It may not be great evidence, but there was some evidence.
Your Honor, we would not, our view is that the evidence, and I know the testimony that Your Honor is referring to, saying that these were the justice companies, that is not specifically evidence at all with respect to the ownership of TAM's management. There was evidence that TAMS had 2 directors in common with one of the other defendants, BII, Bluestone Industries. There was no evidence of common directorship with any of the others. There was evidence that TAMS had some common officers with 2 of the other defendants, BII and Paycar, but no evidence of any common officers with Bluestone Resources, which was the parent of the other 3 defendants.
Well, what was the jury to make of Mr. Graham's testimony, who's BRI's Senior Vice President of Human Resources, that the various entities that were operating at the Burke Mountain Complex were functionally the same company?
Your Honor,
From that, couldn't a jury conclude that they were functionally the same company?
Your Honor, Mr. Graham never mentioned, and his testimony is relatively brief, the portion that's included in the joint appendix, and it begins at Joint Appendix 239. Mr. Graham never mentioned TAM's management at all. The other companies were the Bluestone companies.
Was there testimony from some of the witnesses that they got some payments from BRI?
There was one.
So
I'm
yes.
sorry, Your Honor, BRI, Bluestone Resources.
Mhm.
I think that's correct, Your Honor, but
Was there testimony that all these entities shared the same PO box?
I believe there was testimony.
And was
to
there
that.
testimony that all these entities had the same principal place of business?
Yes, Your Honor, but again, none of that goes to that doesn't establish any of the factors. The fact that these may be operated in the same place, they can even, in fact, in the Third Circuit cases, in Pearson and in tech controls, the principle that's articulated there is that even if you can establish common ownership and common management and incidents that might be expected in that situation, such as a common PO box or a common place of business, that's not enough to establish single employer status under the warrant.
And your time's ticking down. Do you want to address the jury instruction?
Yes, Your Honor,
issue?
I'd be happy to. And our point there is fairly straightforward. We don't believe that the court needs to reach that issue, of course. But if it does, that issue concerns an erroneous jury instruction. I think that my colleagues on the other side of the aisle, I think we may be ships passing in the night here in terms of what our argument is. Our argument is not anything to do with the offer that was made to Mr. Gautier to come back to work after a few months. That's, I think, primarily what plaintiff responded to in their response brief. The argument here is that under the WARN Act, there are three kinds of employment loss: termination, layoff greater than 6 months, or reduction in hours greater than 50% for 6 months. Under the Leeper case from the Seventh Circuit, those three categories of employment loss are mutually exclusive.
And I thought you said in your brief that if the court had presented these as alternatives, that would not have been a problem.
Mutually exclusive alternatives, Your Honor. They can't.
So I was confused by that because in the jury instruction, the court says, now we're going to talk about employment loss. If you find 50 or more were not terminated from employment on such and such dates, the plaintiff next asks you to consider if 50 or more of the defendant's full-time employees suffered a disqualifying reduction or suffered a qualifying reduction in hours. So that sounds like alternative language to me. The court said if you don't find the first category, then the plaintiff asks you to go on and address this second category.
And, Your Honor, our premise is that the jury should have been instructed that they could only find one of those, and that in this case, when there were only 91 members of the class, the jury's finding of that there were 50 employees, 50 class members who were terminated, and also 50 class members who suffered a recognizable reduction in hours, those findings are mutually exclusive.
Well, you might have a problem with what the jury put on the verdict form, right? That they found both. Maybe they misunderstood the instruction, or they just wanted to belt and suspenders and make sure that they communicated what they thought. Maybe they got it wrong, but it's not an problem with the instruction, right? The instruction presented it in alternatives, right?
Our position at trial, Your Honor, was that the jury should only be instructed on one. In other words, that the plaintiff should have to pick. And I see my time is up, but if I may, I'll finish answering Your Honor's question.
Go ahead.
That the jury could only be instructed on one of those bases, and the plaintiffs had to choose one. And if we had prevailed at trial on that, and if the court had not made what we believe to be the error in the instruction, then the jury would have made a finding that made logical sense. Because of the error, the jury made a finding that's logically contradictory given the number of members of the class.
Counsel, can I follow up on that question, Judge Rushing's question? If we don't agree with you that the instruction was incorrect, but might have some sympathy for an argument that the jury verdict was inconsistent as a result of the findings of the jury. Was that argument preserved? Because I don't see anything in the record that indicated that you, or I don't know if you tried this case below, but whoever tried the case objected once the jury verdict came in.
Your Honor, I understand the question. I did not try the case below. I believe that we would have adequately preserved the argument by our objection to the form of the instruction, that if the instruction had been properly given, it would have been impossible to reach the inconsistent finding, and that the objection in that regard would be perhaps not ideal, but sufficient to preserve the issue.
All right, thank you.
Thank you, Your Honor.
Mr. Petzonk?
Thank you, Chief Judge Diaz. It is also for me an honor to appear here and meaningful to me and to our client class to appear and be heard by this honorable court. Thank you. A properly instructed jury had abundant information on every relevant factor to determine the defendants comprised a single employer under the WARN Act and that they terminated more than 50 full-time employees within the class period. There was no contrary evidence to indicate anyone other than the defendants terminated all of the relevant employees. The defendant's entire focus has migrated, really shifted diametrically during the course of this case after they lost 3 times on summary judgment and at trial. The defendant's whole emphasis throughout the briefing was that they were a single employer and that they should get some credit and some offsetting consideration for trying to rehire employees during the class period, an argument that you heard Mr. Ruby say they've abandoned now. They're not here to make that argument. And so we thought we were all in agreement that they were a single employer. That was the argument they were making in their defense all the way through this case. The fact that they rehired a few people at the 11th hour. It's the case that they did make 1 or 2 phone calls to some of the class members 2 days before they filed their answer in this complaint.
And when you say they made some phone calls, it's the phone calls to try to rehire them, right?
Yes.
And who was it that called them?
Yes, Your Honor, that's exactly
Was
right.
it Mr. Graham?
It was Mr. Graham.
Who worked for who?
He was the Vice President of Human Resources for Bluestone Industries and every other defendant.
Mm-hmm.
Yeah, and he testified without contradiction in the record that he had hiring and firing authority for all the defendants.
And I think he also testified that they just switched employees back and forth between companies. That's at JA 241.
That's at JA 240, 241. Yes, Mr. Graham testified he had common hiring and firing at JA 239 and 40, and then he goes on at 240 and 41, as you note, Your Honor, that there was an exchange employees back and forth and machinery back and forth. And, you know, under the WARN Act, you also have to show that the layoff or termination, the employment loss, occurred at a single site of employment, and these factors kind of commingle, and the defendants have not challenged the holding that the affected Burke Mountain mine complex was a single site of employment. Part of what we showed to prove that was commingling of equipment by the defendants, equipment and employees. So it's sort of a half-hearted argument here to argue that we failed to show they were a single employer, but they're not challenging the finding of single site employment, which relies on the same facts of commingling of employees and equipment. So as you note, Your Honors, the Pennington case consciously distinguished itself from a case in which there are common directors and owners, and Judge Wilkinson said in that opinion that this was a case involving a major utility company which had contracted with Westinghouse and the Fluor Corporation, totally distinct companies, and Judge Wilkinson's acknowledged that this would be a totally different case if it involved wholly owned or closely held subsidiaries. And as to Your Honor's question, it's about the evidence regarding common ownership. I think, Judge Rushing, you made the point. There was certainly testimony about common ownership, but it's important to note that when Mr. Ruby says we only showed that TAMS had 2 directors in common with the other defendants, and we didn't show more. Well, the reason we didn't show more is that TAMS only has 2 directors at JA 366, and those 2 directors happen to be Jay and Jill Justice. And so JA 366 is the stock certificate, or the Secretary of State's records on that entity, which show that all the capital stock was held. It doesn't show the proportion, how much Jay owned versus how much Jill owned, and that's basically what they were arguing. We didn't adequately prove that, but that's really immaterial. And of course, the standard here, Your Honor, and Judge Thacker, I know you've thought about the standard for reviewing jury verdicts, and the court today has asked about the relevant standards, and as long as the evidence is within the range of the credited testimony, the jury's verdict should be upheld. And certainly here, the court heard and the jury heard evidence on every element of 20 CFR 639.3, common ownership, common directors, de facto exercise of control, which in the Pearson case in the Third Circuit and in the Pennington case, which generally followed Pearson, de facto control of the employment event, the adverse employment action giving rise to the claim, is the principal factor of interest to the WARN Act. Judge Wilkinson set out the legislative history of the WARN Act, and it's intended to prevent major community disruptions from mass employment, and so the entity that's actually making the decision to disrupt the community is the most important factor under Pennington and under Pearson. And here, all of the evidence about de facto exercise of control went to the commonality of the control by the Bluestone integrated entity.
Can I ask you a factual question
yes,
about
Your
that? Is it right that Billy McClung is who informed the plaintiff that he was being terminated?
As to the class representative,
The
yes.
representative. And he's employed by Bluestone Industries?
That was the uncontradicted testimony, yes. He was not on the payroll of any of the other subsidiaries.
And so was Tiger Lambert?
Tiger Lambert was also not on the payroll of any of the subsidiaries, and he was the superintendent of the job site. Albert Grimmett testified in this case, and I can give you the JA citation, but he testified that Lambert was a Bluestone. Yes.
Both parties seem to say that in their briefs. The defendants also say that these 2 were employed by Bluestone Industries, but I wasn't sure about the record, so I just wanted to confirm.
Yes, they were, in fact, they received a lot of compensation from a variety of sources, but they are, it's not disputed, they were agents of the principal, of not any of the subsidiaries in this case. So we showed also the dependency of the operations. Again, Mr. Graham's testimony and all of the rest of the plaintiff's evidence goes to the dependency of the operations. Really, in order to preserve an argument about codependency of the operations in a WARN Act case, you have to challenge the finding that the mass layoff or plant closure occurred at a single site of employment. And what we showed, and it's not been disputed here, that there were plaintiffs' Exhibit 1, JA 185, there were common work permits, there were all affiliated employees. Josh Lilly testified about that. There was a map of all the permits in the record here the jury saw showing that where on the job site the defendants intermingled personnel, equipment, mining permits. There was the processing of coal occurred at that site too, which is an integral part of a coal mining operation. Albert Grimmett at JA 217 testified about the codependency of the operations. At plaintiffs' Exhibits 2 and 3 were the job listings for the workers during the period. All of the workers from all the defendants were listed jointly on a single job listing, assigning the shifts and assigning the work at the job site. That maintenance of payroll records is a factor that this court looks to for joint employer under Dalton against Omnicare and joint employer analysis. Generally, you look at the economic realities. So for the codependency operations, you got your work lists that support that conclusion in the record, common directors and owners, we've been over that. Plaintiffs' exhibits 4 through 9 showed as to all of the defendants, they had the same directors, they had capital stock that was held by all of them. Payroll records were admitted, plaintiffs' exhibits 13 through 15. JA 373 through 382 summarizes those, showing that those miners who were all under the same direction, who were all working at the same site, were all employed by, in various fashions by a hodgepodge of these defendants, but they were all operating the same business at the same site. And again, it's important, the defendants have not challenged the single site of employment holding below in this case. I want to shift, if I may, Your Honors, well, before I shift away from single employer, there was also check history reports that were admitted into the record through Ms. Leslie Wells, who is the payroll officer for Bluestone Corporate Parent, and those were summarized in the record and authenticated at JA 247 by Ms. Wells. So payroll records. Common control of payroll records also supports the jury's reasonable conclusion. And of course, Mr. Graham's testimony. The court relied, as summing up on single employer, the court relied on all of these factors I've just recited in denying the defendant's renewed motion for judgment as a matter of law. At JA 419, the district court does a nice job of summarizing this evidence that I've just summarized. And the court then goes on to address this, the second issue that the defendants are arguing here.
Before we get to that, counsel.
Yes,
can I ask a question about the sufficiency issue? And at the very beginning, not today, but in your brief, I recall you seemed to suggest that we don't even need to get to the merits of all of this because it wasn't properly preserved in the renewed motion for summary for judgment as a matter of law, and that the argument as to sufficiency was relegated to a footnote. Do you want to say any more about that? I mean, it seemed like the district court engaged with it nonetheless, and that might be enough to get it over the hump, although I think I would agree with you that that's not the best practice.
Well, this may be akin to a situation where someone raises an equitable issue and doesn't, gets a result that's at odds with what they were reckoning for, and then tries to preserve it with an assertion of error. But the reason we felt like they waived this issue of single employer is that they were making the contrary argument below. So they were arguing they were a single employer and that they deserved a damages offset or some credit for rehiring the employees. They were arguing they were a single employer, so we felt they waived the argument that they were not a single employer. That was, and when they lost for the fourth time on the argument about credit for rehiring, then you're right, I think it's reflected in a footnote, and it may have been voiced verbally at the conclusion of trial that they took exception to that, to the verdict at that point on that, but they hadn't presented any argument or evidence about that throughout the trial. They had been arguing our side of that issue, Your Honor.
So I think you're about to get to the second part of the argument that has to do with the verdict, and I have a math question, which is always a dangerous thing for lawyers to engage in. So as I understand the law in this case, I had to show either that 50-plus employees were terminated as consistent with the act and or that they suffered a qualifying reduction in hours. And if my recollection is correct, there were a total of 93 employees subject to the class. So and it seemed like the jury found both of those in its verdict, but that seems to not add up because, well, you tell me, does it add up and why?
Well, there were only 91 you're correct, there were only 91 full-time employees shown in this record to have been terminated from employment during the class period. So that is the case that you couldn't have had 50 employees terminated from employment from full-time employment, and 50 other employees terminated, reduced in hours during each month of the 6 months of this class period. But the defendants misstate in their briefing that the class was only 90. Actually, there are over 160 members of the class. You don't have to be a full-time employee to be an affected
Did it
employee.
have to be other employees? Perhaps the jury thought it was the same 50.
Exactly,
Because
Your Honor.
50 hours to 0 hours is a reduction in hours. So check yes if you're the jury. And then were they 50 of them terminated? Yes.
That's
They were
right.
reduced from, so
The ju-
perhaps the jury did not see those as factually inconsistent or mutually exclusive.
That's right. But as Judge Rushing and Your Honors intimated in your questioning, the instruction directed the jury to make those findings and only to reach the fourth interrogatory if they found in the negative for the first interrogatory. So the court tried to tell them, don't do both of these things, or you don't need to do both of these things. So the answers to the first 3 special interrogatories are fully sufficient to support the verdict here. And you don't need to address the question of your, Chief Judge Diaz as to whether there's an inconsistency in the way that the jury answered the fourth interrogatory. Because as your questioning indicated, they fully resolved those.
In every way in which the jury answered the interrogatories pointed toward liability. That's not an inconsistency in liability or in their way of thinking. There's no confusion as to which side they were on.
Exactly, Your Honor. And then this gets to the defendant's last point about the Leeper case. And the Leeper case is limited in its holding about the incompatibility of the elements of an employment loss under the WARN Act. All that the Leeper court said is that an individual employee cannot experience, logically, both a layoff that lasts 6 months and a reduction in hours of more than 50% during each of month of a 6-month period, because they found that those things were incompatible. You can't be reduced in hours and also fully laid off. But the Leeper court also said and acknowledged that you may be both terminated from full-time employment, which is a determination that turns on your perception at the time you're terminated. It's not a hindsight-driven inquiry. And the Leeper court held this. This court has held it in graphic communications against Quebecor as well. Leeper doesn't even stand for the proposition that Mr. Ruby's suggesting here, that a termination for an individual employee is inconsistent with a reduction in hours of 50%. And just as you suggest, Judge Thacker.
How is it not, though, if, under your interpretation of Leeper, if termination is about the perspective at the moment that it happens, that the employee couldn't both think, I'm being terminated forever, and also think, my employment is just being reduced by 50%.
Well, their state of mind's not relevant to the mathematical question of whether they have been reduced in hours more than 50% during each of a 6-month period, Your Honor. That's the difference.
So you're disagreeing that these 3 categories are legally distinct?
I'm disagreeing that termination is inconsistent with reduction in force. Leeper says layoff for 6 months. If you're laid off for 6 months, they say you don't work any hours during the 6 months. That's inconsistent with a reduction in force. But the subjective inquiry of whether you were terminated in month 1, you may answer that in the affirmative, as the jury did. And then also, now the record here does not show that anybody was called back at the 11th hour. But hypothetically, had they been, those things are consistent. You could have understood and moved. All these people said, they told us the job was shut down, we had to move on. That can happen. And then if you get an 11th hour phone call in the last week of the 5th month, you've experienced both a reduction of 50% for 6 months and a subjective termination, Your Honor. So those things are conceptually, the jury could have answered both of those as to the same individuals, but certainly Leeper doesn't say that you can't have 45 people, for instance, who are terminated and 5 people who are reduced in hours, and the jury certainly could have thought that. And here there was the most evidence at trial. Leslie Wells suggested 2 people were actually restored during the last couple of weeks of the 5th month. So jury could have thought 48 people were terminated, 2 were, you can add those together to get an employment loss under the WARN Act. Leeper doesn't say you can't. Leeper doesn't say you can't add together a layoff of 6 months for 48 people and 2 or 3 others get reduced in hours. It's just not for one individual person. You can't have both a 6-month layoff and a reduction of 50% for 6 months under Leeper. But this court doesn't need to get into that here because, as you suggest, Judge Thacker, the instructions were adequate. The first 3 interrogatories fully secure the verdict, and the instructions, as you suggested in your questioning, Judge Rushing, presented it in the alternative. And the jury thought it was answering both. I think it's legally sound for the jury to have answered both as to even the same individuals. You don't need to get into that question about whether there's a statutory inconsistency or logical inconsistency between prong 1, termination, and reduction, like the Leeper court had to do. Does that, you with me on that? So I hope you don't feel compelled, Chief Judge Diaz, to go down that road. The evidence here is fully sufficient to preserve the verdict, and we disagree that they preserved it. I think Your Honor's question whether defendants preserved this issue, even if they did preserve this particular subspecies of their objection, the standard, and I guess I'll close with the standard, is whether construed as a whole, the jury was informed of the controlling legal principles without misleading them to the prejudice of the objecting party. And even if they did preserve this kind of objection, it wasn't to their prejudice because the instructions were sound, the verdict was sound regardless. So we would ask for you to please remand the case for the delivery of our remaining fee motion, which is the only thing left over to be adjudicated. Thank you, Your Honors.
Thank you very much, counsel.
Your Honors, I want to begin with the question of waiver because I think we can dispense with that fairly quickly. There was no waiver at trial of the, or post-trial of the argument that there was not sufficient evidence to support a finding of a single employer under the DOL regulation. At JA 290, that's JA 290 is the party's or the motions for judgment as a matter of law at the conclusion of the evidence. And at that point, there's several pages, as a matter of fact, of discussion of this very basis that the defendants urged for their motion for judgment as a matter of law, specifically that there was insufficient evidence, and the argument tracks very closely, as the court will see, the arguments that we're making here today. There was several pages of argument there, several pages of response by the plaintiff, and then in the post-trial motion for judgment as a matter of law, the arguments that were made at the close of the evidence were specifically incorporated in that motion. And Chief Judge Diaz, as you noted, the district court was certainly well aware of what those arguments were and engaged with those at some length in its order denying the post-trial motion. So I don't think there's any question that there's waiver here. The theory of waiver that my friend Mr. Petzonk has articulated, that there were contradictory arguments or arguments that he viewed as inconsistent that were made at an earlier stage of the case, certainly that's an argument that a party could make, that its opponent has made arguments that are mutually contradictory in some respect, but it does not establish that there's been a waiver. I want to touch broadly, Your Honors, on the expansion of precedent that would occur on the single employer point if the plaintiff was to prevail. We're not aware of any case where a court has applied the WARN Act single employer principle outside the context of a parent-subsidiary relationship or in very narrow circumstances, a lender-borrower relationship. That's a point that was made in the Pennington decision that this court handed down in 2019. And the overarching point there is that when you have separate legal entities, as the 5 defendants in this case undisputedly are.
I thought Pennington was focused on de facto control when it talked about that.
That's correct, Your Honor. So
But there are other factors at issue here. Here, we're not relying solely on de facto control, right?
That's correct, Your Honor. But my reading of Pennington is that generally, and I think the point that Judge Wilkinson was making there was the de facto control, I think, undoubtedly is the preeminent factor in the Pennington analysis. I agree with that. I think the broader point that was being made there is that this aggregation of employers into a single employer is unusual, and that when it happens, the precedents where that occurs or has occurred are generally parent subcases, as opposed to cases like this where you have 2 completely different entities, or
And
TAMs.
I think generally might be the key word there, because in Pennington, it said, quote, in the WARN Act context, courts have found direct liability in only 2 circumstances, which is what you're hanging your hat on. But it didn't foreclose liability in other circumstances. It just then just made that statement and then addressed
I agree with that, Your Honor.
the factually distinguishable case of Pennington there.
I agree with that, Judge Thacker. And my contention is not that Pennington forecloses the application of single employer status in any other circumstance. My point is that we're not aware of any case where that's been done outside of the parent sub or lender borrower context. The plaintiff has not cited any such case in his
Well,
brief.
The plaintiff cited this case. This will
Sure,
be the
yes.
case, could be the case.
Correct, Your Honor, but it would be, we believe that it would be an expansion of precedent, and that it would expand precedent in a way, particularly in terms of the reliance on evidence, a lot of which is the subjective impressions of employees at the site that these were all one company. That is, if that sort of evidence is sufficient to establish single employer single employer status in a WARN Act case, then it significantly expands the category of WARN Act cases where single employer could apply if the subjective impressions of employees at the work site is a significant enough factor to establish
But I
it.
think the jury could also take the testimony, couldn't it, of the employers and then also of Mr. Graham, who was the head of HR and security for
Mr. Graham's testimony, and I see I'm running short of time, and so I'll simply ask the court to look at the joint appendix on this. But as I mentioned earlier, Mr. Graham's testimony was specific to Bluestone. His position was with Bluestone. His discussion of moving equipment and employees around to various parts of the mine site was specific to Bluestone, not to TAMS. And here, critically, TAMS is a separate entity from BRI. I want to touch briefly on the...
But didn't he testify about that the exchanged employees and that they were all on various payrolls, and some of the employees at TAMS were on the payroll of other companies?
I think, Judge Thacker, what you'll find in the joint appendix in Mr. Graham's testimony is that he actually never mentioned TAMS. Wasn't asked about it, didn't mention it.
Right, he didn't mention the word TAMS, that's true. Did he mention Burke Mountain?
He, I believe, mentioned Burke Mountain, but again, his position...
What is Burke Mountain? What company?
Burke Mountain was the mining complex where, various parts of the complex...
For TAMS?
Different companies, including TAMS, had an operation, but the TAMS operation, again, was legally distinct from the others. Chief Judge Diaz, I wanted to come back to your question. I think the math doesn't add up on the employment loss issue. The parties did agree. I just want to make a few quick points here. Number one, the parties agreed that there were 91 class members, that was the relevant number for purposes of this analysis. That's page 11 of the opening brief, note 3, that explains that. The Leeper case does say that the 3 categories, the 3 buckets or types of potential employment loss under the WARN Act are, that they are distinct, that those are mutually exclusive, that even though a termination does imply a reduction of hours, that those are not the same thing under the WARN Act. And the problem, the prejudice with the inconsistency here is that it makes the finding of the jury unreviewable because we don't know what the jury found. They found 2 logically inconsistent things, and therefore it prevents this court from undertaking a meaningful review of that and prevents us from meaningfully challenging it.
How do we
on
not
appeal.
know what they found? We know they found 50 or more were terminated, and we know they found 50 or more had their hours reduced.
Correct, Your Honor, but they could not have found both.
But they did. We know they did.
Yes, Your Honor, but because those
Right, there's no confusion about, well, did only a few jurors find, 20 employees and a few found 20 different employees, and we can't add those up because we don't know if they're the same or different employees. None of that is a problem here. Here, the jury found 50 or more, and they found it two ways, right?
And a better way of saying it on my part, Your Honor, might be that the jury can't have found, or can't with justification, can't viably have found both of those things because there weren't 100 employees. It can't have legitimately found, correctly found, that there were 50 who were terminated and that there were 50 who had their hours reduced. And without knowing which of those things, and I understand Your Honor's point, they did find both. Those findings are so mutually inconsistent that it prevents meaningful review of what factual determination the jury actually made there in order to check both those boxes. And if there are no further questions, I think that I'm a bit over time at this point, Chief Judge.
Thank you very much, counsel. Unless my colleagues have any questions.
I do not.
Thank you, Your Honors.
I want to thank both counsel for their arguments this morning. My colleagues will come down and greet you, and then we'll move on to our final case.
Thanks. I don't know if you can see them, Chief Judge, but the lawyers appear to be ready.
Okay, thank you. Our fourth case is 24-2103, Roberts v. Evans. Mr. Gillespie.
Thank you, Chief Judge Diaz. Good morning. I'm Reggie Gillespie. I represent the appellant, Justin Evans, and I will join the other lawyers who've told you today it is a privilege to appear before this venerable court. I'm glad to have the chance to do so. There are two basic questions that have to be decided in every qualified immunity case. Those are whether a constitutional right was violated and whether the right so violated was clearly established at the time of the violation. In this case, there was a involuntary commitment order. And the involuntary commitment order...
And when we consider those two issues, do we take the facts as the district court found them, correct?
Well, there is case law that says that, Your Honor, but there are other cases that say, for example, the court is not bound by a party's version of the facts. There's clearly distinct...
Not a party's version of the facts, the district court's finding of facts.
Neither the parties nor the court are bound by something that is contrary to the record. And that's the point that we're relying on here in this case. and I'm referring to the Scott case. In the Scott case, the court said that the parties are not, nor is the court bound by the district court's finding. What the Supreme Court said in Scott was that facts must be that when opposing parties tell two different stories, one of which is blatantly contradicted by the record, so that no reasonable jury would believe it, a court should not adopt that version on a summary judgment motion. In this case, the plaintiff's version is what the court adopted, and our position is that it's a story that is blatantly contradicted by the record, and therefore this court is not bound by it.
In what way is it contradicted by the record?
It is contradicted by the record in multiple respects. First and foremost, the plaintiff has admitted one of the most fundamental facts of all in this case, and that is that she had no evidence to contradict Captain Parker's description of what happened in his return of service section of the involuntary commitment order. In that return of service, Parker documented what happened as follows. Roberts, the decedent, attempted to kill or cause serious bodily injury to the officers serving the involuntary commitment petition and order, and as a result, the officers responded, resulting in the death of the respondent. The plaintiff testified in her deposition that she had no evidence to contradict what Captain Parker documented in his return of service. Parker's description of what happened. Actually, plaintiff added in her deposition that she was told that Roberts had attempted to kill the deputies with a machete. The plaintiff gave this testimony.
Mr. Gillespie,
Yes, sir.
sorry to interrupt you.
Yes, sir.
What you just indicated is obviously correct what she said, but I don't know if the district court actually engaged with that, but could that be viewed as simply her statement that she personally had no evidence to contradict what the officer had said, but that doesn't necessarily exclude the possibility that there is other evidence in the record that might contradict what the officer had to say, principally the autopsy report, which is, I think, where the district court largely hung its hat on, is the sequence of shots, if you could even call it that, that suggested, or a jury might conclude that the officer, in this case, Corporal Evans, shot the decedent in the back. And so that's the evidence, even if the plaintiff didn't remember it. And the question is whether that's enough to create a genuine issue of triable fact.
Let me answer that, Your Honor, in two parts, if I may. First of all, the plaintiff gave her testimony months after every single officer was deposed, months after the expert reports were submitted in this case, including the forensic pathology expert as well. She's represented by a very able counsel, and at her deposition, she did not contest what Captain Parker documented in his report.
But what he documented in his report is what he says happened, and to Chief Judge Diaz's point, she wasn't there, so she truthfully testified she couldn't contradict that.
Well, yes, Judge Thacker, and I'm coming to the rest of your question. In the autopsy report, there's absolutely no finding whatsoever that the findings or the interpretation that the district court gave to the autopsy report, which the plaintiff also gave to the autopsy report, it simply doesn't support those particular findings. For example, the autopsy report nowhere says that plaintiff was unarmed, but that is something that the district court and the plaintiff contend the autopsy report stands for. It does not say that. As a matter of fact, the autopsy report indicates that Roberts died as a result of an armed confrontation with the officers. So it contradicts that. Secondly, with regard to the contention that the shots were fired within 8 feet, the autopsy report actually says that the shots were fired from an indeterminate range. It says that to every single one of those shots. Thirdly, the autopsy report indicates where the bullets entered and exited, but it does not interpret where Roberts was facing, where he was going at the time he was shot. As a matter of fact, the physical evidence that's there that is uncontradicted is that Roberts fell backwards and landed on his back inside, and the pictures from the scene, which are in the joint appendix, show he fell backwards, landed on his back inside, with his feet facing towards the door. So we submit that the autopsy report, which does not make the findings that the plaintiff contends that it says, that the district court contends that it says, it simply doesn't say that. If the court looks at the summary interpretation at page 546, all it says is the cause of death of Adrian Roberts, a 37-year-old man, is attributed to multiple gunshot wounds, X3, involving the left arm, torso, and neck, resulting in internal injuries to the rib cage, lungs, aorta, and left arm bone with associated significant blood loss. Post-mortem examination additionally revealed no evident contributory natural disease or alcohol drug toxicity. The decedent was reportedly fatally shot during armed confrontation with law enforcement, serving involuntary commitment papers involving him. That's the armed confrontation, and that's repeated in the autopsy report. In view of the overall death investigation and post-mortem examination findings, the manner of death is classified as homicide. That is the sum, substance, and entirety of the summary of interpretation in this report. Our position is that neither the district court, nor a jury, nor the plaintiff is qualified to interpret this report in the fashion in which it is being interpreted to defeat summary judgment. And that stands in stark contrast to the opinion of Barbara Wolf, a forensic pathologist who's done more than 10,000 autopsies. And Dr. Wolf describes that the injuries are consistent with how Justin Evans and all the other officers who saw it, that his version and their version of what they saw, what they perceived, is what the autopsy report indicates. And so there is no interpretation that supports the district court's finding. There is only the interpretation that is directly contrary to it, and that interpretation is not controverted, it's not challenged in anywhere in the record. Let me say also further. Yes, ma'am.
This might be a good summary judgment argument or a good jury argument, but I thought you were relying on Scott to try to get around the problem with appealing a denial of summary judgment. And Scott sets a very high bar. It says it has to be blatantly and demonstrably false, right? In that instance, the court had a videotape that showed it was blatantly false, the version of facts that the plaintiff presented. And Scott even distinguished cases relying on documentary evidence and said, this rule, this exception to the rule is not going to apply in most cases, but here there's a video that shows that version is blatantly and demonstrably false. And how do you get over that?
In two ways. First of all, what Scott says is blatantly contradicted by the record. And the record is, in this case, 4 officers observed the decedent running at them with a machete over his head. The physical evidence confirms that when he fell on his back, landed on his back inside, a machete was found, 2 machetes were found, one within his reach. So we also have the perceptions of the officers, which must be credited. And I would suggest to the court that the Sigmund case speaks to that. In the Sigmund case, the Chapel Hill police officers who were attempting to take into custody a subject who was intoxicated and wielding a knife, according to them, he was shot and killed. There were 3 witnesses who gave affidavits that said that he didn't have anything in his hands, he was not a threat at all to any of the officers, and they shot him without justification. Those facts were in the summary judgment record, but what the court did was it credited the officers' perceptions, none of which were contradicted by anything in the record, all of which were consistent with one another. And what the court said in Sigmund is that the officers' perceptions cannot be overcome by these witnesses' affidavits, even though they seem factually to be different. What the Sigmund court said is that summary judgment was appropriate in that case, notwithstanding those affidavits that appeared to contradict the officer's perception.
But again, here we're on a denial of summary judgment, right? So all we're allowed to look at typically is the question of law. We're not allowed to consider whether the court was correct in finding that there was a dispute of material fact. We have heaps of cases saying that we're limited to looking at whether accepting the facts as the district court found them, right? The plaintiff's version as the district court found it, would that establish qualified immunity. Would there be qualified immunity under that? Is it not a constitutional violation, or was it not clearly established? Do you dispute that taking the facts as the district court found them, there would be a constitutional violation that's clearly established?
If, as the court found, which we disagree with,
Right.
that, as the court said, that the decedent had his back turned, was walking away, and didn't have any weapon. If those are the facts, then yes, there would be a constitutional violation. But we respectfully submit that those are not the facts, and the record blatantly contradicts them. And furthermore, we submit that these officers' perceptions, which are not contradicted, and indeed which are actually corroborated by the physical evidence, are what this court can and should and must rely on. And it's entirely consistent with the Sigmund case for this court to do so. I would also like to turn to the other element of the qualified immunity analysis, and that is whether a right is clearly established. And in that, I would ask the court to consider this, that there is no case by this court. Well, I was going to start out with, let me review the involuntary commitment order very quickly. The involuntary commitment order states that to any law enforcement officer, the court orders you to take the above-named respondent into custody within 24 hours after this order is signed, and take the respondent for examination by a person authorized by law to conduct the examination. So that is the order in this case, and I respectfully submit that neither this court nor the Supreme Court has ever recognized a clearly established constitutional right to use or threaten force, deadly force, against law enforcement officers who are executing an order commanding them to take a person into custody for a mental health examination. Neither this court nor the Supreme Court has ever so held that that's a clearly established right. And as a matter of fact, in the Rembert case,
Right, if that's what happened, but that's what the court found was a genuine issue of fact here as to whether, and that's where we find ourselves, going back to what Judge Rushing said.
I understand that, Your Honor. Let me also, consistent with what I've just stated, is the Rambert case, which says there's no precedent from this court or the Supreme Court that requires an officer to refrain from deadly force when faced with a suspect's aggressive and violent actions because of the possibility that the suspect may be suffering from mental health issues. I recognize that we seem to be going around to the same point, but the point is essential. The point is this, and that is that there is no evidence to contradict the officers' perceptions. They're uniform, they're consistent, and they're also consistent with each other, and they're also consistent with the record. The physical evidence in this case, and the only evidence to the contrary, is an interpretation of the autopsy report that we submit is not competent. Indeed, that's a question of law for this court to take up. If it's not competent, then it's not sufficient to deny summary judgment in this case. It's not sufficient to refuse qualified immunity to the officer. So for these reasons, we respectfully submit that this court should, based on the numerous cases that have taken summary judgment and reviewed them and reversed denial of summary judgment. Those include the Elliott case. Those include the Rambert case, which I just spoke about. Those include, of course, Scott, and those include a case from Chapel in the Sixth Circuit. And those cases and 6 or 7 others, including Caraway, which Judge Diaz, I believe you wrote the opinion in that, Chapel, Gooden, Rambert, Signum, as I just mentioned, and Waller, and Anderson versus Russell, all of which are cited in our brief, have all credited officers' perceptions. And at least 2 of those, Anderson versus Russell in the Waller case, credited those perceptions, even though those perceptions turned out to be mistaken. So we respectfully submit that this court should rely on these officers' undisputed perceptions. Thank you, Your Honors.
Thank you very much, counsel. Mr. Coyle?
Thank you, Your Honors. May it please the Court, John Coyle on behalf of appellee Sparrow Fisher Roberts. The case law of the Supreme Court in this circuit, is very clear. We can only deal with discrete issues of law on interlocutory appeal. In Hensley XRL, North Carolina versus Price, this court specifically said that on appeal, the court cannot credit defendant's evidence, weigh the evidence, or resolve factual disputes in defendant's favor. That's explicitly what appellant is asking to do here. The only discrete issue of law is once we take the facts as the district court found them, which is that Adrian Roberts was unarmed, his back was turned, and he was walking away from the officers, whether that spells out a violation of clearly established constitutional law. You heard from appellate's counsel himself, it does. There's no dispute on this issue. As Your Honors noted, this sort of issue of revisiting the facts that appellant tries to do based on Scott really isn't appropriate here. Scott is very much a very specific case where there was video evidence of the entirety of the incident that dispelled any disputes that may have existed. Appellant also cites to a Fourth Circuit case.
Well, opposing counsel says the autopsy report itself dispels the factual scenario that the district court found. What's your response to that?
I don't really see how we get there. The autopsy report is much longer than what was quoted by counsel. If we go to pages 543 to 546 of the joint appendix, it shows you entrance wounds, bullet trajectory, how it moves, and most helpfully on joint appendix page 547, there's a diagram. And that diagram shows that all 3 entrance wounds of the bullets are in Mr. Roberts' back. So they certainly have presented expert evidence that there is some feasible way that the body could be contorted and comply with Mr. Evans' version of events, but it's very easy for a jury, and certainly the district court here, to determine that these 3 entrance wounds and their directional path forward in the body demonstrates that his back was turned when he was shot. That coupled with the testimony.
Sorry to interrupt. But the district court also relied on the autopsy report to find not just that, but that when he was shot, the decedent was about 8 feet away and that he was unarmed. So obviously, I don't see how the autopsy report could lead to those conclusions. So what else in the record supports those findings?
The distance is, I believe, based largely on pictures, coupled with their testimony, Mr. Evans' testimony, that he was outside or basically in the door jamb versus how far away Mr. Roberts fell. There was also some discussion in various deposition testimony about the distance between 5 and 8 feet, which generally what the deposition testimony said. As to the unarmed aspect, Captain Potter testified at his deposition. He was stationed at the window, which is to the right of the door where entry was made. He testified that he was giving the signal for when entry would be forced. He waited until Mr. Roberts had nothing in his hand, had his back turned, and he was walking away from the door for them to signal entry. There's also deposition testimony that from the time of the forced entry to the first shots was 1 to 2 seconds. So we do have evidence, testimonial evidence from the captain saying he had nothing in his hand, was walking away when forced entry happened. Gunshots happened 2 seconds later, 3 entry wounds in the back. All of this supports the district court's finding that there is a material dispute of fact that when read in the light most favorable to the plaintiff, that he was unarmed, he was walking away, and he was shot in the back.
Was it that same officer who then said that he then saw the decedent turn back around and looked like he might have had something in his hand?
He does give that testimony, Your Honor, but there's such a short time period that a jury can credit or discredit that testimony. And that testimony is easily discredited when you look at the autopsy with the entrance wounds, all 3 across Mr. Roberts' back. So what we have here is a material dispute of fact, and what we're doing right now is dancing with material disputes of fact, something that the Supreme Court in the circuit has said we're not allowed to do. Only in situations where there's video evidence that makes it very clear what happened, Or like in Elliott versus Levitt, plaintiff has no evidence at all, only their conjecture about what happened. Can we then say that it is an abstract issue of law? There is no abstract issue of law. The question here is whether he was unarmed and walking away, or whether he was attacking the officers with a machete. And that dispute is material, and the district court found it to be material, and there's no jurisdiction to review here. Unless the court has further questions, I'll yield back my time.
Thank you very much, Mr. Coyle.
Thank you. I want to ask the court to consider the Elliott versus Levitt case from this court from 1996. In that case, there was no evidence to demonstrate the existence of a genuine issue of material fact. Consequently, the officer's appeal for denial of summary judgment based on qualified immunity was properly before this court. In that case, Judge Wilkinson noted that the district court considered there being an issue of fact. But the court looked at the evidence, looked at what was, that is the evidence in the record, this court did, and found that the plaintiff did not meet its summary judgment response burden because it did not come forward with evidence to show a genuine issue of material fact. Summary judgment, there are still requirements that a party must meet to survive a motion for summary judgment. It can't simply rest on its allegations of its pleadings alone. In this case, Justin Evans made a motion for summary judgment, which he supported by evidence in the record. It was a properly made, properly supported motion for summary judgment, and that does not entitle the plaintiff to simply rely on allegations, insinuations, innuendo, and interpretation of an autopsy report that simply isn't supported by the report. So in this situation, summary judgment should have been granted and would be entirely appropriate. I want to also point out once again that the officer's perceptions are what this court can and should rely on. And there are 7 or 8 cases in this circuit alone that deal with that. And that's important because that's what we have here, is we have the officer's perceptions as to what occurred. And these perceptions are backed up by the fact that the machetes were found near his body, that he fell backwards and landed on his back, that he fell facing forward. And Captain Parker testified, it wasn't contradicted, that when that battering ram hit the door the first time, he turned around and ran towards the door with something in his hand over his shoulder. That was at the first strike, but that didn't open the door. The second strike is what opened the door, and that's when the incident occurred, where ultimately he continued coming forward, and that's when he was shot. And all these officers saw him coming towards them and saw him with a machete, which was found at the scene. The autopsy report doesn't contradict that. What we have is a
Mr.
situation.
Gillespie, can I ask a follow-up, a question that Judge
Yes, sir.
Rushing was asking when you first came up to the podium about the competing standards here? So you quite correctly indicated that in a typical summary judgment motion, when the case is up on appeal, you know, we do take the facts in the light most favorable to the non-moving party, but if there's no evidence in the record to support those facts, then we don't credit those. But the problem here is you've got a qualified immunity motion at the interlocutory appeal stage, which imposes, I think, superimposes an even stricter standard on an appellate court with respect to findings of fact that a district court might make, wrong or right. And you may end up winning this case at summary judgment, on final judgment, or at trial. But you see, my point is that there's 2 different standards here that you have to overcome, and I wonder whether you overcome both of them.
Your Honor, may I speak to that in 2 ways? First of all, the Scott case, Supreme Court says the summary judgment practice does apply. Secondly, Elliott versus Levitt says summary judgment apply. And in Elliott versus Levitt in particular, because the plaintiff had failed to meet his burden of showing an issue of fact that the party moving for summary judgment, that the officer seeking summary judgment and qualified immunity, this court held that that was insufficient to satisfy his summary judgment burden and reversed the trial court and granted summary judgment for the officer. We respect that this case lands directly within Elliott versus Levitt, and Elliott versus Levitt requires this court to apply the same summary judgment standard that applies to other cases that Scott applied, and that applying that, this court should reverse the trial court's denial of summary judgment. Therefore, we ask that this court deny the trial court's, reverse the trial court's denial of summary judgment.
All right, thank you very much, Mr. Gillespie.
Thank you.
I want to thank both counsel for their fine arguments this afternoon. Looks like it's afternoon. My colleagues will come down and greet you, and then we'll adjourn court for the day.